Dallas, you're on WDBO. Go ahead.
Yes, I just have a quick question for you. Well, I guess it's not a super quick question, but my soon-to-be ex and I are separated, and we own two properties together. We're trying to figure out a way to set up a way for us to be able to, take some of the proceeds from the sales of the homes, but then have some of the money remaining in some sort of an escrow or a trust account, so that neither of us, can have access to the money and, take off with it without, having the marital debts paid for. My family law attorney told me to, find out whatever we do to make sure it's legally binding, and he's not the one that can deal with that and needs more of a real estate, attorney to do some work like that. Do you know what could be done in a situation like that, where the court system is bogged down with COVID and we're trying to just be able to move forward with, the plans to sell the homes, yet have a way that, things can be distributed?
So
one home may sell first, one may sell later.
I get it. Forth. So Dallas, I get this strategy, and that is that you sell these properties. Some of the money is dispersed to the two of you. Some of the money is held in escrow until you guys figure it out about how to divide it, how to pay certain marital debts, I suppose. Dallas, when you sell these properties, you're going to have a title company, and that title company potentially could be the one to act as your escrow agent. That title company may say, hey, we don't want to do this, and therefore you may need to hire an attorney to put that money into his or her trust account. And your attorney right now, I think, is telling you, hey, I don't want to do it because I'm not a neutral third party. I'm representing Dallas. So maybe you do need an attorney. But in either case, whether it's a title company that holds that money or an independent law firm trust account that holds that money, the key is to have a good escrow agreement that is as detailed as possible as to how that money will be divided in the future. Dallas, no matter who holds that money, you could have an escrow agreement that's crystal clear, and yet usually that money is going to be locked up until somewhere down the road, both you and your soon-to-be ex sign a document telling the escrow agent how to divide some or all of that money. So I get where you're coming from, Dallas. So I think the key is finding an attorney or a title company that would act as your escrow agent, and then having a well-drafted escrow agreement signed by you and your present wife.
Okay. Sounds good. Is that something that your law firm does as well?
Dallas, I would say the answer to that would be yes. Number one, we're a title company, so when it comes to selling these properties, we can definitely close that transaction for you. And as far as drafting an escrow agreement as to how this money will be held and dispersed down the road, yes, Dallas, I could do that for you.
Okay, so you're both a title company and a law firm.
We are. We do both, yes.
Okay. Great. Thank you so much. I really appreciate you answering my question.
All right, Dallas, we look forward to being of service to you. And that's a great question. Chrissy, it kind of makes me think about this, is that when people buy and sell houses here in the state of Florida, it is typical that when the contract is signed, the buyer puts up a good faith deposit. Let's just say $5,000, okay? This is not Dallas's scenario.
Right.
This is just a typical buyer of a typical home.
Right.
And the buyers in that contract, there are contingencies that provide that the buyer must get financing, is contingent on the buyer getting good inspection that meets with the buyer's approval. But what the buyers don't often realize is that once that money is put into an escrow account, usually the title company, it is locked up until both the buyer and the seller sign off and tell the title company how to disperse that money.
Mm-hmm.
And so the buyer may be saying, hey, it's here, black and white, crystal clear. It couldn't be any more clear that this escrow should be returned to me, and that the title company will say, well, yeah, you may be right, but we're not dispersing it unless the seller signs off too.
That comes down to policies and procedures of a title company and or an entity holding an escrow.
Exactly,
correct?
Yeah.
So in addition to the agreement, what you're saying is there's still going to be the standard policies and procedures in place that will have to take place too.
Exactly. And so often the seller will say, hey, what motivates the seller to go down and sign a form saying that, yeah, go ahead and give the $5,000 to the buyer? Nothing. So usually it often works out that even though the money should be returned in full to the buyer, sometimes it works out that the buyer must agree to give some of that money to the seller, even though the seller doesn't deserve it, just to get the seller to sign off on the thing.
And once again, because they both have to sign.
Yeah. Now, that would be a typical contract. And if the buyer came to me and said, Tom, I'm really concerned about this, I want to make sure I can get my money back. Well, not only do you have to have a typical contract, you have to have some very specific escrow language
Put
there
into it.
that would provide that hopefully the title company would be comfortable enough saying that, hey, we're going to return this money to the buyer even without the seller's signature consenting to it.
That would though require you
That
to
would
do
require
something.
me,
Yes. Okay. Yes.
If you have a typical contract done by a typical real estate agent,
and a
it's not
typical
gonna
with
work.
the title company, that the normal process will be they both have to sign off. If somebody wants to have special, additional, something other than what is the normal, that would require you to be able to work with the contract and everybody to agree.
Yeah. Let me just talk about the other side of the coin for a minute, okay? And that is this, is that I've had plenty of calls over the years, as you have, and it comes from the seller. And it says, Tom, the buyer put up a $2,000 good faith deposit. The buyer has defaulted. That $2,000 should belong to me. I call the title company. The title company says, well, we're not going to release it to you unless the buyer signs off on it.
Right.
And guess what? What motivates the buyer to go down there and sign a form saying, give the money to my seller?
Nothing.
Nothing. So once again, the seller often has to compromise and say, then and this, give some of it to the buyer, even though they're not entitled to it. Let's split it 50-50, for example. If once the seller has been burned like that, now they know that black and white is not all that it seems on these contracts. They'll come to me and say, Tom, I want you to draft it in such a way next time that if this happens again, that title company will give me that money without this buyer signing off on it. And yeah, we can do that. But if you have a typical contract drafted by a typical real estate agent, and that is not a slam or criticism about real estate agents.
No, that's the
then
far bar.
That's
the way.
That's the way it goes.
Yes.
Yeah, yeah. Nobody. I am not criticizing real estate agents. The bottom line is that when a contract is signed by a buyer, a seller, prepared by a real estate agent, everybody goes into it thinking, hey, the deal's going to close. Everybody's going to be happy.
Right.
The buyer's going to get a home he loves. The seller's going to get their money. Real estate agent's going to get a commission.
All
Everything's
good.
going to turn out beautifully. But when it doesn't, then that's when people start getting upset about these escrow deposits.
And of course, interestingly, there's been more of this issue on these escrow deposits and you would think, oh, it's all about if something goes wrong, as in there's an inspection issue or there's a finance issue. But more recently, a lot of these have been a problem because of the fact that one or the other party, with the market the way it's been, with prices being inflated and sellers thinking they can get more money and buyers backing out, that's when really there's been more issues with these escrow deposits, right?
Yes, exactly. Yeah, it's been more of a problem in the last
The
few
normal.
years than it normally has. Yes. So just keep that in mind when you're doing a contract. Now, occasionally, Christy, I'll have a seller come to me and say, Tom, I'm going to enter into a contract for sale and purchase, and I want to make sure that if the buyer defaults, I'm going to get to keep the deposit. My response to him is, well, the best way to handle it is to have the buyer's deposit not held in a title company escrow account. You, the seller, hold that good faith deposit.
Okay.
And if we can get the buyer to go with that, then, man,
That's the better way.
That's 100% guaranteed that if the buyer defaults, the seller's going to get that deposit.
But once again, everybody has to agree up front.
Everybody has to agree to it.
Yes.
Yeah. And it can certainly be done. There's no law that says a title company has to hold the deposit. But that, from the seller's perspective, that's the best protection that they might have.